Not all visas are created equal in the Philippines. One of the many things I'm getting a lot of emails and comment about is the meaning of the different type of visas in the Philippines. Sometimes, a comment is left on my channel asking a question about visas, but by the time I get to answer it, someone has already beaten me to it and has answered it. Unfortunately, more frequently than I would like, the answer given is the wrong answer. So rather than correct people, I thought I will make a video discussing the two main types of visas, the 9A tourist visa and the 13A resident visa. Not all visas are created equal, but I have learned that I could say the grass is green, the sky is blue, and someone will disagree. But on this channel, if anyone disagrees with the information given, they can say why. But do not just simply a blanket statement saying I am wrong without giving a valid reason. On this channel, we want basis and even jurisprudence and be prepared for a rebuttal. The visa policies of the Philippines is governed by the Commonwealth Act No. 613, also known as the Philippine Immigration Act, and by the subsequent legislation amending it. Anyone thinking about coming to the Philippines have probably heard about the 9A visas, which are also known as tourist visas. The type of visa given at the airport to visitors arriving from 157 countries, which vary in duration from 14 days to 59 days, depending on the passport held. The most popular for viewers of this channel are Australia, Canada, Japan, Switzerland, United Kingdom, and the United States. It is for 30 days or less, providing they will hold a valid ticket for their return journey to their point of origin or their next port of destination, and their passports are valid for a period of at least 6 months beyond the contemplated period of stay. Now, many come to the Philippines with the intention of residing and hold what is known as a throwaway ticket, a cheap ticket that gives impression they intend to travel on within 30 days to their next port of destination. But they don't have any plans to do that and just throw away the ticket after gaining entry. The numbers given to the different types of visas come from the Philippine Immigration Act. Section 9 of the Immigration Act, which is titled Non-Immigrants, states, quote, unquote, aliens departing from any place outside the Philippines who are otherwise admissible and who qualify within one of the following categories may be admitted as non-immigrants, quote unquote. The categories are listed by letters so as a 9A visa means Section 9 Category A, so it becomes 9A. Category A is a temporary visitor coming for business or for leisure or for reasons of health. So the law states 9A is a visa for temporary visitor coming for business or for pleasure or for reasons of health. Temporary visitor's visa is available to foreign nationals who are traveling to the Philippines for the common purposes of: first is pleasure, for holiday or leisurely stay. Second, business, may be of commercial, industrial, professional character, but must be temporary in nature, like those who are attending international conferences, or here to negotiate contracts or attend business meetings. The third one is health, provided not contagious, loathsome, and or dangerous diseases. What you cannot do legally on a 9A visa is work in the Philippines, but many do. For example, if you want to come as a missionary to the Philippines to help poor people, you need a missionary visa, which is a 9G visa. The details will be in Section 9 Category G of the Immigration Act as amended, or as a student, it is a 9F, again the details of which will be in Section 9 Category F of the Immigration Act. The 9 series of visas for non-resident visas or temporary visitor visas, the holders have limited rights protecting their stay in the Philippines. A different series of visas are the resident visas, the 13 series that get their name, as I mentioned before, that the numbers given to the different types of visas come from the Philippine Immigration Act as amended, Section 3 of the Immigration Act, which is titled Immigrants. Quote unquote, under these conditions set forth in this act, they may be admitted into the Philippine immigrants term quota immigrants, not in excess of 500 of any one nationality without nationality or for any one calendar year, except that the following immigrants term non-quota immigrants may be admitted without regard to such numerical limitations, unquote. A foreigner whose country has an immigration reciprocity agreement with the Philippines and married to a Filipino is qualified to apply for permanent resident visa. Qualified to apply, quote unquote. Some think that merely act of marrying a Filipina means they automatically have the same rights as someone who has applied and been granted a 13A visa. That is not the case. Under the Philippine Immigration Act of 1940, Section 13A, they are eligible for permanent residency in the Philippines. This visa is issued to an alien on the basis of his valid marriage to a Philippine citizen if applied for and approved. To qualify for this visa, the applicant must prove that he has contracted a valid marriage with a Philippine citizen, and the marriage is recognized as valid under existing Philippine laws. Another is there is no record of any derogatory information against him in any local or foreign law enforcement agency. He is not afflicted with any dangerous, contagious, or loathsome disease. He has sufficient financial capacity to support a family and will not become a public burden. He was allowed entry into the Philippines and was authorized by immigration authorities to stay. Now, if he qualifies, he can apply for a Section 13A provisionary visa. After a year, he can then apply to amend the 13A provisionary visa to a non-quota immigrant to a 13A permanent visa by marriage. The main difference between a 13A permanent visa and a 9A tourist visa is the rights granted in the Philippines to a holder of a 13A permanent resident visa. Notice I said rights, not privilege, because for the holder of a 9A tourist visa, his stay in the Philippines is a privilege. And for a holder of a 13A permanent resident visa, he is in the Philippines as a right. A 13A visa holder can work in the Philippines and a 9A cannot. This recent travel ban applies to 9A visas but not to 13A visa holders. Not all visas are created equal. But remember, generally a tourist visa is just a visa to come to the Philippines for leisure. Unfortunately, some tourists think once they are in the Philippines with their tourist visa, they can do whatever they want, just renewing their visas every few months. They even set up businesses. Sadly, I have seen some of these tourists within weeks of turning up in the Philippines with their YouTube channels advise others about Filipino customs, Filipino traditions, Filipino laws, and even information about visas. After a stay of 59 days in the Philippines, foreigners need an ACR I-Card. An ACR I-Card is a microchip-based credit card-size identification card issued to all registered aliens whose stay in the Philippines has exceeded 59 days. It also has an embedded computer chip with biometric security features capable of data management and can be updated electronically. All foreign nationals under immigrant and non-immigrant visas, including holders of temporary visitor visas who have stayed for more than 59 days in the Philippines, need one. The color of the ACR I-Card depends on the visa category. For permanent residents, it is light yellow. For a probationary resident, it is light purple. And for a worker, it will be blue. And a tourist on a 9A visa, it will be white. So if anyone is giving you advice about bank accounts, working in the Philippines, first ask what color their ACR card is. Because if they are going to give you advice based on their experiences as a light yellow ACR I-Card holder about doing business in the Philippines, it won't be the same if their card is white because it's a different visa. As I said, not all visas are created equal.